Call Julianne Genter.
Tēnā koe, Mr. Speaker. Tēnā koutou e te whare. I rise to speak on the Construction Contracts Amendment Bill at the first reading. The Green Party will be supporting this bill, at least to select committee. I would like to note that most of the changes in the bill are actually relatively minor. Many of them are neutral. Some positive changes in the bill include the requirement for adjudicators to hold a pre-adjudication conference to answer questions about the process, and a requirement for all adjudication notices to contain a statement of the respondent's rights and obligations and a brief explanation of the adjudication process. These measures will make the process more transparent and understandable to participants. We think that is a desirable and good outcome. One negative change we're concerned about that we will be exploring in the Select Committee is the move to shorten from 15 to 5 working days the amount of time defendants have to apply to the District Court to oppose a plaintiff's application for a determination to be enforced as by entry as judgment. While the clause would require adjudicators to give a respondent additional time to serve a written response on the claimant if additional time is necessary, owing to the size or complexity of the claim, the shortening of time could have negative impacts on the fairness of adjudication, and that's what we're concerned about, particularly where a claimant is unable to hire a legal representative for financial or for other reasons. One other thing I'd like to bring up is what's not in this bill. So, back in 2010, the government undertook a review of the Construction Contracts Act 2002, and there were 2 significant recommendations out of that review that have not been taken up by the government for legislative change. And those 2 exceptions were strengthening remedies for non-payment and ensuring a mandatory scheme for security of payment. And both of those actually became very relevant earlier this year, when Mainzeal went into receivership. And of course, one of the reasons that they went into receivership was poor corporate governance by people like Dame Jenny Shipley and other friends of the National Party. It turns out that there hadn't been annual reports sent to shareholders for several years, it looks like, and there's certainly none publicly available. So it's impossible to know what sort of directors' fees the Board of Directors were receiving right up until the time that they exited the board. That was right at the end of last year, early this year. And another reason for Mainzeal's problems was the leaky buildings. And of course, that is as it should be. They were involved in a number of buildings that turned out to have significant problems. But I think it's worth pointing out because this government seems to be opposed to all types of regulation and seems to be on the side of, less regulation is always going to get a better outcome. And the leaky building problem, which has been enormously costly to taxpayers and to homeowners, is a perfect example of where light-handed regulation actually ends up costing society and the economy quite a lot more in the long run. And so it's much better to have that regulation in place to ensure that the problem doesn't start, rather than to say, look, we want to reduce compliance costs, we want to free up red tape, like with this special housing zones bill that's currently before the House. The government wants to get rid of any oversight by the RMA, wants to remove any requirement to comply with district plan regulations in order to get houses built cheaply and quickly with no consideration of what the long-term impacts will be. And there will be long-term impacts. So the Green Party is not supportive of regulation for the sake of regulation, but let's be honest, it does serve a purpose, and it serves an important economic purpose. It's not just a cost imposed on business. It actually can be there to ensure that there are better long-term outcomes. Because in the economy as it currently exists, there is a huge incentive for players to maximise their short-term profit with no consideration of the long-term impacts on people, the environment, or indeed the economy. And it's really the role of government to have that oversight. And when government gets too close to vested interests, as we have here in New Zealand at the moment, we have a government that's very clearly looking out for its mates and a number of vested interests, then the lawmaking suddenly is not providing long-term oversight in the interests of New Zealand Inc. Rather, it's under pressure from vested interests to remove regulations which in many cases might be useful, important, economically important, in order that these vested interests might make another big profit this year. Never mind what's going to happen in the future. So, back to Mainzeal. Look, the problem with Mainzeal is that we have subcontractors, hard-working subcontractors, tradespeople, who are likely not going to be paid because of Mainzeal going under. And this was flagged as a problem during the review of the Construction Contracts Act 2002. And Brands commissioned market research in September 2010 to scope the nature and extent of contractors not getting paid. And the key findings of the research were that 61% of respondents had instances of non-payment in the previous 5 years. That's pretty significant. 61% of respondents had had instances of non-payment in the previous 5 years. Most respondents indicated that the total amount of non-payments was under $50,000, but there were cases of non-payments over $500,000. And so here we have the opportunity in this bill to ensure that there are mechanisms available to address this problem. And one of these was a mandatory security of payment scheme. Now, the government came back and said, oh, well, security of payment measures are already available in the market and people can freely engage in them or not. But it really misses the point that the purpose of a mandatory scheme would be to ensure that nobody is disadvantaged by other people being willing to not accept security of payment. If you're a subcontractor, if one is a subcontractor and they're going for a job and it's a big construction company like Fletcher's, who's pretty much a dominant player in the market, they could say to the subcontractor, well, there's someone else who will do your job without the security of payment. We don't want to have to go in for that because it's going to cost us more money. And so the competitive incentive means that people are less likely to be able to have the security of payment measure or to choose to go to that. And that's the purpose of having it be mandatory. We need some insurance because it's simply not fair when large property management construction companies go under that the subcontractors don't get paid. They're the guys who actually have to feed their families. They're not the guys who are jet-setting around, like the corporate boards of directors hanging out in the Corn Club. So what the Green Party would like to see, and we will be seeing what comes out of the Select Committee submissions process, what the public have to say, what the stakeholders have to say, if indeed the stakeholders do feel that there is scope within this bill to address this issue of non-payment, then we'd like to see some amendments to the bill to deal with that problem, because it's been a problem this year in 2013. It will doubtless continue to be a problem in the future, and we need to look after the workers and people of New Zealand. Thank you, Mr. Speaker.
Honourable Tau Henry.
Mr. Speaker,